there is the Attorney General William Barr this morning at the press conference that was done prior to the release of the redacted Mueller report. With me now is Ronn Blitzer, senior legal editor with Law&Crime. Ron, thank you very much, because I need some help digging out of this this mess here. You've had a chance to look over large chunks of the report, I'm assuming at this point. What did you focus on? Just give me some high points from your perspective.
So I focused on those 10 episodes of potential obstruction that Barr was referring to, because, you know, as he said in his letter and as Mueller says in his report, when it comes to collusion, there was no collusion. The report concluded that there was no conspiracy, no coordination between the Trump campaign and Russia, even if Russia was trying to help the campaign and the campaign knew that they could benefit from Russia's actions. They were not working together.
They certainly didn't have a problem with it.
Right, they had no problem with it, but they weren't involved in it, and that's fine. But when it comes to obstruction, there were a number of different instances that Mueller addressed. He did not reach any legal conclusions or prosecutorial judgments, as Barr had alluded to, but he does show that he's leaning in certain directions in certain instances. For instance, Trump's response to news about Donald Trump Jr.'s Trump Tower meeting, and when emails came out and when there were stories about to be reported about that, and how Trump was involved in crafting the statement addressing that was a little bit misleading. Mueller, had written about how, while Trump was involved in this and was trying to maybe keep information away from the public, this was not obstruction of justice because this had nothing to do with any judicial proceedings. So there's no legal issue there. When it comes to some other instances, such as Trump's reaction to Mueller's own appointment and trying to get Mueller fired, that's where it got a little bit interesting, because what's ironic here is that this whole investigation stemmed as a result of concerns about Russian interference and whether or not the Trump campaign was involved, and we learned that they were not. Then Trump himself became a target of the investigation after he fired FBI Director James Comey, and there was a concern that there was obstruction of justice when he fired Comey to kind of put an end to the investigation, and that's when Mueller was brought in. But it was Trump's then treatment and attitude towards Mueller that I think raised some of the biggest issues. He had apparently asked White House counsel Don McGahn to have Rod Rosenstein fire Mueller, and Don McGahn refused to do that. After McGahn refused to do that and considered quitting over it, Trump didn't bring it up again. But the idea that he attempted to have Mueller fired raises flags, because to be found guilty of obstruction, you don't need to have succeeded, you only need to have attempted to.
Steps in the process.
Exactly. And then there was another instance where Trump apparently had his former senior advisor, Corey Lewandowski, who had previously worked on the Trump campaign. He wanted Lewandowski to deliver a message to Jeff Sessions, who had already recused himself from the investigation, but he wanted Sessions to talk to Mueller and restrict the scope of the Russia investigation to only focusing on possible future efforts of election interference, which would bar any investigation into the Trump campaign or Trump himself. And that Mueller found, would be impeding an official investigation that was ongoing. However, a big issue when it comes to obstruction cases is proving the requisite intent. And as Mueller said in his report, the intent, the standard here is tremendously high because it requires that someone acted corruptly. Now, when going into the discussion of Trump wanting to fire Mueller, it talked about Trump's initial reaction to finding out that Mueller had been appointed special counsel. And it was not good. He was not happy about it. He even said, "This is the end of my presidency." But he was then carrying on about what he thought were conflicts of interest that Mueller had. And there were a number of conflicts that Trump felt Mueller had, one being that Trump had already, right before the appointment, had been considering hiring Mueller to be the director of the FBI, replacing Comey, and opted not to bring him on in the end. Another issue involved what he claimed to be a dispute that Mueller had over membership fees at a golf club that Trump owned in Virginia. So he thought that there were actual conflicts of interest. Now, Trump's advisors, including Steve Bannon, said that this was ridiculous and that there were no real conflicts and no basis for Mueller to not be special counsel. But if Trump himself believed that there were conflicts and that there were good reasons for Mueller to not be special counsel, and that's why he wanted to get him fired, then you could have an argument to say that even though he was trying to take action that could have gotten in the way of the investigation, that he wasn't doing it for corrupt purposes. He really believed that there was a problem.
Okay, so it sounds to me like, and I made this guess, having not read it, that there's so much going on in here that no matter which side you were on, if there was a side prior, you've got something to glom onto and argue your point for or against obstruction. Yes or no?
Yes, absolutely. I think that no matter which side you're on, you can point to certain things and say, that's obstruction, or no, it wasn't obstruction. And that's why when you're dealing with criminal investigations here and prosecutorial judgments, you need to decide whether you can prove your case beyond a reasonable doubt. And if you don't think you can do that, then you shouldn't be bringing a case, particularly one against the President of the United States, where you have a political firestorm that would ensue should you actually do that. So when William Barr and Rod Rosenstein examined Mueller's findings and determined that they were insufficient to support a prosecution for obstruction of justice, I agree with that. Yes, there is evidence that you could point to if you were bringing a case, but given that there is, such a gray area when it comes to intent, and there really, in my opinion, is not enough evidence to support the idea that Trump was really trying to do something corrupt, especially since there was no underlying crime involved here. I think it was the right call to say, no, we're not going there.
And so I could analogize it, I think, to a jury decision. When they say not guilty, they don't mean innocent.
Right.
And so here we have a situation in which you can't really exonerate, but they didn't find enough to pursue charges.
Right. So when Trump says that it's a full exoneration, when it comes to collusion, yes, but Mueller said that he would have said so if he was going to exonerate him for obstruction, and he couldn't do that. So it's not an exoneration on obstruction, but yeah, I read it as a not guilty because there just isn't enough to go on.
Yeah. So I do believe there will be more conversation. I don't think we've put
I don't doubt
a period
that.
or an exclamation point on the whole process. Ronn Blitzer, thank you so much, senior legal editor here for Law and Crime. Appreciate your insights, and keep me posted on what's happening with this. I know he's going to have a great article coming out too, so keep an eye on that at lawandcrime.com. And you can look at the entire 448 pages in your leisure at lawandcrime.com. We'll come back in just a couple of moments, right back here.